All right, welcome everybody to Masterclass. I am excited about this topic. Demitri and I have known each other for what, about 3-4 years now?
Actually, it's more like 2.5.
Okay.
3 years.
3 years, 3 years. So we met through the Sierra Angels, and I frankly never knew that much about patents and IP because I was a software guy. That was not a world that we lived in. And over the last couple of years, I've learned so much from Demitri, and he's got like more degrees than I think there are people in this room. And it's not like, oh, he's got like a master's in, I don't know, something fluffy. No, it's like physics, engineering, really hard stuff, like you would expect for somebody who's an expert on, what is a patent, what is worthy of a patent, and what isn't. And I am so excited to hear this topic because he is a true master at it. So the myths and realities about the value of patents. Please welcome Dr. Demitris Paraskevopoulos.
Thank you, Jeff. Good evening, and thank you for inviting me to discuss with you what I consider to be the fascinating subject of patents. Before I start, I have some questions for you so I understand better where you're coming from and what your interest may be about patents. So my first question is, how many of you are entrepreneurs versus investors? Let's say, how many are investors? And how many are entrepreneurs? Okay, we're equally divided. Good. Now, how many of you in your business, either as an entrepreneur or as an investor, you have dealt with patents? Less than half. And how many of you have actually been more involved in the development of patents? By the way, Chad is an exception for a number of reasons I'll explain later. Okay, so practically almost no one. Now, how many of you, that's a tougher question, have you wondered whether it is worthwhile investing in patents? Good. Now, if you've been involved in a company, whether entrepreneur or investor, and they have patents, did you ever wonder after the fact, after getting patents, what is the value of those patents? Good. So that's what we're going to address. I hope by the time we finish, you'll have answers to all those questions. And by the way, you do not need to wait until I finish. You can ask questions anyway, anytime during my presentation. Feel free to interrupt. So there's 4 types of intellectual property. And many times people use the term intellectual property and patents interchangeably, but it is not. Patent is only one of the 4 types. However, in high tech, the two are almost synonymous. Why? Okay, so the first one is patents. It is a grant from the government to exclude others from practicing what you have invented. They're good for 20 years, and there are 3 types: utility, design, and plant. Excuse me. But the ones that you will always be dealing with are utility, not worth for small companies to design patents. Now, this is a big fallacy that some inventors have. Well, I'll keep my technology as a trade secret, and I don't have to get any patents. I don't have to disclose it to anybody else. Well, let me assure you that in high tech, whether you're a small company or a large company, unless you're Apple, you cannot keep trade secrets. And by the way, there is no legal protection against copying your trade secret. So if I find out how you're doing it, I can copy it. You have 0 protection. You think that you can keep it a secret, but we'll talk about that. Copyrights, this is the form of protection of human creation, writing, printing, and so on. But again, this does not apply really doesn't provide any protection in high tech. And of course, trademarks, again, until you become a very, very large company, your trademark becomes valuable, but when you're small, it's of no use. So for high tech, only patents matter, especially for smaller companies. Now, I submit that whether you're doing hardware, software, systems, trade secrets are of no value, because once the technology is disclosed in a product, I have every possible advanced reverse engineering technique to copy it. And then you're not protected. But even if I don't want to go into that cost, as I say, high-tech people in smaller companies, medium companies, they talk. They talk to their friends. They talk to their wives. And by the way, when I set a target to go and find something out about it, I can wine you and dine you to the point that you will disclose eventually everything about it. So trade secrets, please do not ever claim that the trade secret will protect your company. So intellectual property, by the way, is very, very important in the broader economy. Back in the mid-70s, so 50 years ago, 80% of the value, of the economic value of the S&P 500 companies was in tangible physical assets. 30 years later, it reversed. The 4 types of intellectual property we said, because brand for big companies is important and so on. 80% now is in the intangible assets, which are basically protected by intellectual property. And of course, 20 years later, coming to today, I don't know how much higher it can go from 80%, but certainly has increased. So it is the dominant value of companies today. And I think about who are S&P 500 companies and how much of that do you think is their technology? However, when companies, private companies, happen not to do well because of competition, because of whatever reason, but they have developed some very good technology, usually the last remaining asset is if they have excellent patents. We'll talk more about that in a bit. So this is not something that, many people, and investors eventually, including very large VCs, when the companies aren't doing well, they shut off the lights, they walk away, and basically they throw the patents away. But sometimes those patents are worth a lot, and we'll talk specifically how much they are worth. Now, last year, there were 750,000 patents issued in the world, half of them in the US. The largest companies, in fact, non-US, had the largest number of patents, starting with Samsung, had the most patents issued to them, followed by TSMC, that's a semiconductor company, Taiwan, and now in the US, then followed by Intel, IBM, and so on. At the same time, each year, the last several years, there have been 2,500 patent infringement suits in the US. Now, this is the 2,500 compared to that is a minuscule percent. So keep that in mind again. We'll talk more about it. So what is a patent? A patent is the right to exclude others from making, selling, offering for sale, or importing into the country of the patent something that you have invented before them. In some ways, we can say that the patent is a government-sanctioned or sponsored monopoly. They give you the right to practice that invention for 20 years. After 20 years, it becomes public domain. Anybody can use it. And by the way, that's the contract with the government. The government says, you're going to teach your invention to the world. I will protect you for 20 years, but after that, you've taught it and people can use it. And that's kind of what grows the economy further. It is only good in the country that it is issued. So every country has their own patents. A US patent does not apply to Europe or China or anywhere else, and vice versa. And now, it is limited to what is called the patent claims, not the patent specification. Patent specification is the many, many pages you see in a patent describing the invention. But at the end, there is a set of claims that are almost like a paragraph long each. And maybe you have 20 of those, or 30 of those, or 40 of those. But that's a limited set of descriptions of what the patent describes. The value of the patent is in the claims, not the specification. So people think that a patent gives an inventor the right to make their products. That's actually not correct. If you have an invention and you want to put in a product without getting a patent, you are absolutely right to do so. Nobody can stop you. In fact, once you put in the product and you put it on the market, nobody can come after you. If you don't have a patent, they can copy it, but they cannot stop you from making your own product. If they're much larger, they can squash you, but that's different. So the patent is not the right to incorporate an invention into a product, but the right to keep others from copying that invention. And so in essence, what the government has given you is the exclusive right to threaten competitors that you're going to sue them for patent infringement if they use your invention, and ask them to pay you royalties or licensing fees, so on and so forth. Questions so far? Not yet. Okay. Now, look at this. Every year, that has been true for decades. 60% of the patents originates from small firms and 40% from large firms. Just a statistical fact. And by the way, there's many, many more small firms than large ones. However, when we look at the economic value of the patents and who gets advantage of them, 95% or more is obtained by the large firms and a very small percent by the small firms. So you say, now, wait a minute, how come I'm a small firm, I have 60% of the patents, but I get 5% of the value?
Yeah, how come?
Because you
Fact.
have like the Intels and the IBMs and so forth, they basically have huge market share.
No, we'll explain that in a moment. But keep that dichotomy in mind. Just something that basically leads to patent quality that we'll talk about later. There is something called the prior art search. To apply for a patent, you have to search that nobody else has invented this thing before, because if you don't search for it, as you formulate your patent application, you simply say it out without what we say, stick your head in the sand. You have no idea who has invented what, but you're going to just send it to the patent office. The patent examiners will examine prior art, and they're going to come back and reject all your claims or most of your claims by saying, look, A, B, C, and D inventors have developed this as prior art. Now, the fact is that, first of all, small firms or their attorneys that do their patents spend very little time in doing prior art. Why? Because prior art costs. Well, let's kick that back down the road. Well, those of you who are engineers, this is like putting a product in the market without doing some alpha testing or beta testing. And you expect now the customers to throw it back at you, telling you what's wrong with it. You get that analogy? Very costly, if not fatal.
Yeah, that's the lean startup. That's what lean startups do.
Yes. Now, small lawyers of small firms do very little prior art. Large firms do none. Well, the reason is because the law used to say that if you're aware that you are infringing somebody and you're caught, you have treble damages. So
It has a policy that we're not allowed to search.
Mary is not an engineer. She works for operations for Oracle. She gets the memo every year. Do not look at prior art of patent. Now, that's not quite the case today, as it was until recently. But about 5-6 years ago, the US Supreme Court made a clarification that it is not whether you knew of the prior art to be liable for treble damages, but whether you should have known. Now, that's a little bit more difficult to prove in court, but yet it raises the bar for companies to be found negligent or violating patent law. Patents are costly. The average investor, by our statistics, takes about 80 person hours. And this is just the application. More work to be done once rejections come back from the USPTO, and we have to deal with them and so on. And it used to cost altogether from start to end about $30,000. That's out of pocket expenses besides the time involved. That's now, it's already about 40K, inching up to 45. We know things are getting a little bit more expensive.
How long does it take to get the application?
Well, it depends. I mean, typically it takes, if you have a process in place, it takes typically a couple months. Can it be done in 2 weeks? Yes. We call it emergency room case. Can it take 6-8 months if people do not know what they're doing? Yes. So it varies. But typically, I would say the average is about 2 months.
How long does it take to get issued or?
Okay,
response?
again, it
I
depends.
know that's-
The average about 2 to 2.5 years. There is now an accelerated path based on either the age of the inventors or paying more money. So the USPTO actually is probably the best US government agency. It is the only agency that makes money,
Self-funded, yeah.
self-funded. Until a few years ago, the Congress used to take their money and spend it elsewhere. Eventually, they got wisened up and they said, no, we cannot do that anymore. So they're good business people, and they say, hey, pay me more money, I'll put you higher on the stack. And rightly so. Now, everybody knows about the technology aspect of the patent, right? This is the technical part, the engineering part, hardware, software, whatever. And you have to teach the ability, you have to teach the invention. That's the requirement for you getting a patent from the government. There is the legal aspect to be able to have your invention to be patentable, to have the proper best claims in place. So this is known. What's usually rarely considered is the third one. That is, what is the business aspect? What's the value of that patent? I mean, if it costs $35,000, $40,000, $45,000, and it takes from an engineer, 80 person hours, more later, in a small startup, I mean, this is a lot. This is like a week and a half, 2 weeks, depends how many hours they put. If they're doing 3 or 4 patents at the same time, that's a very high cost. Is it worth it? What's the patent strategy? Not every invention should be patented. The portfolio, the patent portfolio, should be considered what the military would call a perimeter defense. Not a single patent. You have to have a few circling your business. And not every possible invention that every engineer wants to get patented should be patented, because some of them are like redundant or frivolous. So how you put together the right portfolio from an economic point of view is very important. And again, because everything else we do in business has a return on investment. So those 3 things, the business, the technology, the legal, they have to be balanced equivalently. They all have to be looked up. They have to be considered with the same importance. Okay, some details here. Who is an inventor? Now, back at school, graduate school, people write papers. There's the student. There's the professor. Professor hardly does much about some oversight, but the professor expects that his name will go on the technical paper, right? Not so in patents. If you're the CTO of a company, but your inventor next to you has an invention, all you do is you funded her, you supported her morally, professionally. You are not entitled to have your name on the patent. Also, if Josh back there was a co-inventor, but during the evolution of the company, you guys locked horns, so Josh left. So you filed now a patent in which he was a co-inventor, but you say, out of sight, out of mind, forget him.
I can very much imagine this scenario.
That's why I picked him. This is a very strict requirement. Not everybody follows it, but when it comes to litigation, this is the first thing that litigators will look at, are the proper inventors on the list. If there is somebody more or somebody less, this is instant invalidation of the patent. Yes. I will tell you, when you go into court proceedings, only if there is litigation set. But important patents will be litigated. And I mean, they're like the investigative hounds they have out there and tools are amazing. And they can always find out who were the prior employees, what they were doing. Just used to work for this company. He used to work for Maggie. Let's go and interview him. And of course, he's going to spill the beans. Oh, those. You get the point. So inventors, something has to be very, very strict of those who truly contributed. By the way, funding the research does not qualify you to be an inventor. Being the boss does not qualify you to be the inventor. Ownership and what's called assignment is to whom the patent belongs. And that is your company, unless you, as an individual, is the company. And that's why you'll see in vast majority of patents the name of the inventors, then below you'll see the assignee to whom it belongs. Now, if you paid for the development of the technology and the patent, if you own the company, yes, you are the owner of that patent. Disclosures. Again, I don't want, what I'm going to tell you is not 100% exact. I don't want to spend too much time on it, but mostly, if you disclose your invention before you file for a patent, you lose the right to file a patent. Unless the disclosure is under a non-disclosure agreement, a signed non-disclosure agreement. The moment you file for a patent, your protection starts. But again, it's not 100% protection. So my very strong recommendation to you is that never disclose what your inventions or your patents are all about. Now, you have to talk to investors, you have to talk to customers, you have to describe your technology. There is a very, very simple criterion. You can disclose what your invention is all about, but not the how. Okay, keep that in mind. Now, we say sometimes those two may be overlapping. Talk to somebody who understands and will guide you through. But avoid talking about the how of your inventions and your patents.
Can you talk more about the,
Yes.
this, where you said, be careful about patents licensed from third parties?
Thank you. Thank you for bringing it up. I almost skipped it. We'll talk in a minute about quality of patents in general. Let me tell you from vast experience that patents from universities are of lower quality than the average quality of patents out there. Very low. There's a lot of reasons for that. So if your company is licensing patents from a third party, be careful how much they have invested, what kind of quality they have used in the development of patents. And in general, university patents are highly problematic.
What?
Problematic. I have dealt with large portfolios of patents from large universities, let's say where they have 1,000 to 2,000 patents active. And what would be of the high quality, you can measure on one hand or maybe two. So be very careful. They do not know what a good patent is. And universities, they try to stay within a budget. And by the way, all they care is to eventually transition, if not offload, the technology, the lab, and their patent applications to somebody else. And then they're kind of become absentee landlords. It's just not the right motivation, not the right experience how to do that. Yes, Maggie.
You said the right motivation. It almost seems like they are forced, professors are forced to file for patents, to keep their jobs, to justify their jobs, to get research grants.
One of the metrics for a successful grant is how many patents are generated from funding of that grant.
One of the judgments of how
One of the
successful a
metrics,
grant is.
one of the metrics for success of the grant is how many patents result from the grant.
Okay, but it has nothing to do with the quality of those patents.
Nope.
So they are motivated to
Just get the
try
patent.
to patent.
Well, look, I've spent a lot of years, decades in academia. I think what it is absolutely true is that the success of a university professor, researcher, is how many papers they write.
Research papers.
They can't use revenue as a metric of success for the money they got from the grant. So whoever gave them the grant can't use revenue because the university can't go into business and sell
That's
So-
the whole-
it. But they use the patents, the funding organization can use the number of grants.
So how many technical papers they do? It's very important. I mean, this is almost number one thing other than, teaching. How many patents becomes almost tertiary at best? And here's the other thing. Sometimes, you remember what we discussed about public disclosure? They go and publish a technical paper and then they try to go and file for a patent.
To shoot themselves in the foot.
Yes. By the way, I said it's not exactly that. You have sometimes under certain circumstances, you have a little bit of leeway in time, where if you go quickly after only in the US and file an application, then you may be okay. But this is like now playing with fire on the dates and the deadlines. Yes, it's very disappointing, the patents from universities. Now, large firms file a lot of applications. You remember how many we're talking about a year they get issued, and many of them from the big companies. But only a half, or sometimes only a third of the applications ever get approved. Now, some of you should guess one of the reasons why that's so.
It's defensive, so it.
No. I'm looking for something else. I already mentioned it before. There you go. They don't do prior art. They don't do prior art. So the examiner comes and says, no, this is already invented. Okay. That means that for every patent that they get approved, they had a double or triple cost to get that patent. But that's okay for them. We'll come back to that. And I explain why they don't do prior art. And their strategy is very clear, what the military would call carpet bombing. Okay? Nobody in here, whether you're an investor or entrepreneur, can afford this patent. I mean, this strategy. You better have patents that are like absolutely guided missile to the target, right? So the last 10, 20 years or so, twice as many patents that we said that have been issued belong to the small companies. But they only get 5% of that value. Where is the dichotomy? That's a puzzle, right? Here, by the way, you may start realizing why every large company, every large high-tech company that we know of has been working for decades to try to with Congress to try to outlaw patents.
Outlaw them?
Yes.
Wait,
They cannot because thanks to Benjamin Franklin, patents are part of the Constitution of the US. So they've been sniping at it, chipping away, left and right. Why is that? Because if twice as many, if 2/3 of the patents are out there, potentially creating a problem for them, that's a big exposure, right? So they don't want those things to exist. They want to remove the exposure. So they are being a continuous tug of war in the Congress of the US between large companies and small companies. And it's a pendulum that actually swings quite violently on one side or the other side. Goes back for the last 25 years. But thank God it's a pendulum. Right now, it's swinging in favor of the small entities. What do you think is the probability that large firms infringe patents of small entities? I will show you the result, but then give me a show of hands of how many of you guessed right. So make a guess, hold it. Now show me. Whoa! Okay. I didn't expect that, but you're absolutely right. It's 100%. That's the exposure they have. This is why they know that. This is why they don't want to have patents in the world. But given the fact that patents exist, they do carpet bombing, and they own still most of the economic value.
how often do they get caught?
Aha, we'll come to that. Thank you. We'll come to that. So given that they know, believe me, every one of them knows that they're infringing patents, what do they do about it?
So if the small company comes to them, they buy them out? No, nothing.
They do nothing. In fact, I have been told again and again, when I approach a big company on behalf of a small entity and say, hey, look, my friend in the big company, there's some patents here, you can buy them basically with petty cash. Their answer is, no, Dimitri, thank you for bringing it up, but we'll do nothing until you sue us. Because if we open up the door to you, there'll be 10,000 companies with all of those patents coming after us for the same petty cash deal. We don't even have the time to handle it. But they know, back to your question, to be sued is very low probability.
Small companies get off.
Exactly. So the patents that small firms obtain, in their mind, is for defensive purposes. Even though sometimes you can put out your product there and you're protected, except that somebody can copy it, and then if they copy it, most of the time there's nothing you can do about it. So the majority of small firms do not succeed in business. We know the odds, especially as angel investors. So when they go out of business, their patents, big companies don't worry about it. Even if they succeed, somehow, they don't have a patent infringement litigation cost between $4 to $8 million in legal fees.
Yeah.
And if you're going after an Apple or equivalent, double that. They know that. By the way, my observation is many investors and management, they sort of have a DNA, oh, we don't sue people. We don't. Why not? I mean, it's money. I thought you are in business of making money. Oh, no, we don't sue people. The large companies, the other thing they know is that not only you will not be able to go after them, but they know that many of the patents out there, including theirs, but also for the small companies, are of low quality. So let's talk about what is quality of a patent. I like to define two metrics for quality. You own patents, and some company is coming to you to buy those patents or license them. In fact, believe it or not, there is auction systems for patents. So there's value that people pay for it at an auction. So if your patent would pass this licensing quality, it's good enough, is at that level. But now raising the bar, fewer patents will stand litigation, scrutiny in the court system for litigation. So what is the fraction of its patents? Again, I will show you that. I will let you guess both of them. And after I show you the results, we'll go each one and you show me, show of hands, who guessed right. Everybody ready? Who guessed correctly on the licensing? Wow, okay, 3. Very good. Who guessed correctly on the litigation? Whoa. I'm curious, what did you think the rest of you on the licensing, roughly?
5.
Oh, also very low? Yeah. Yeah, no, it's about 20%. Now, let me clarify something. One does not get litigation quality patents by birth, by the first patent, because it may be very well described, but the claims can never be perfect. There is a system, a procedure in the US where one can go and improve that, especially because to go after an infringer, one has to match the patent claims to the features of the infringing product. You have to do this mapping. Now, it's hard to know that way ahead of time, but you learn that along the way. And there is a process that you can make that matching better and better. So what I'm trying to say is that you must have patents in this category of 20% and then work hard to get them to the 5% level. It's a whole different discussion. I'm not going to go into it. But again, the 5% doesn't happen in the beginning. So, but look what this says. 4 out of 5 patents that people have invested money have no value. You cannot even recover the cost that you got to get the patent.
They will of any quality, you can't litigate because you don't have cash.
Oh, besides that, yeah. No, but people say, oh, you know, they go and they negotiate with their attorney and they want a 10% discount on the fees or something like that. You're losing 80% anyway if you don't do it right. Now, those of you with the Sierra Angels or recently with AngelNV, we go through some patent assessment. And I don't know what the percentage, I did not calculate that, Jeff, but I think probably because everybody comes to me to see what the quality is, probably I keep killing, probably. But, excuse me, once in a while I say, that's a good patent, right? So maybe 1 in 5.
It seems like less.
Less. Maybe that's an old statistic. So you already understand that the number of patents that small firms can use to litigate against large firms is very, very small. That's the 5% of the value at the end of the day. This is why large companies have 95% of the economic value, because small firms cannot, are afraid, whatever, do not go after to extract the economic value that they have.
I've got a really dumb question. Being in the US, but if you have like a traffic injury, like a personal injury, the lawyers seem very happy to pursue these things. How come that hasn't happened?
Oh, it does. Okay, you're the straight man here, Chad. Hold your question. Come back. So large corporations know that they infringe 100% of the time. They also know that not very many companies can go after them, so they choose to disregard the patent law. And I'll tell you, if I was in their shoes, I would be making exactly the same decisions. It's a common sense economic decision they make. So we talked about the 95%. Now, the predominance of patents that small firms get is for what I would call defensive value. They want to make sure they can operate, freedom to operate, including getting check marks by their investors. So we'll call that the defensive value, V sub D. But if a patent is successfully asserted against a large infringer, and the large infringer has to pay now a lot of money, we'll call that the assertive value of a patent. Okay? And again, I want you to guess. What is the ratio of V sub A to V sub D? How many times more valuable is the assertive value of a patent versus the defensive value of the patent? So everybody thought about it? How many of you guessed right? That comes back to you, Chad. If that ratio is 100, how come there isn't a wind from people who will come in? Now, how many of you have heard, you know about VCs, you know about angel investors, you know about private equity. How many of you have heard of litigation investors? Okay. There are huge, huge billion-dollar or more companies that their business is to invest in litigation outcomes, including patent infringement litigation. So the 4 to 8, 8 to 16 billion dollars, whatever, excuse me, whatever it is, it's not something that you have to come up with as an investor or as an entrepreneur. But they don't just invest into anything. I was looking at the recent study that from all the startup companies that come up for investment, the range, depending on the year, was between 5 to 7% will get any funding. Actually, last year it was 6.1, the average. That's 1/16. And each one of you know, one way or another, how difficult it is to get funding. You have to go and talk about your products. You have to talk about the economics. You have to talk about the technology and so on and so forth, the market. The same or similar thing is going on for a litigation investor to undertake a case. Different dimensions, but the same three main dimensions. You have to show why your patents will be held valid, will not be invalidated by prior art. You have to show why there is infringement, because you have to have improved your claims to show the mapping between the product, the features of the product, and your claims. And you have to show that the economic model is in place. Why? Because if it takes $5 or $10 million to litigate a patent infringement, and they are going to get, let's say, roughly half of the outcome. So the outcome has to be 20 million for them to break even. Now, nobody invests to break even in this life, right? At least not knowingly. So they got to be at least 3 times that. So suddenly the damages have to be 50, 60, $100 million. So they have to see, we have to present to them why the damages can be so large for them to undertake. So, but there is. Not everybody knows how to do that, but this is what's happening. So if the defensive value of the patent is in the millions of dollars, the assertive patent value of the patent can be in the hundreds of millions of dollars. Now think about it, hundreds of millions of dollars. how do people consider that in the valuation of their company, their portfolio? Usually they do not. So I submit, and actually I have observed it, there's a third type of exit. Everybody knows about an acquisition of a successful company or an IPO, right? But what if somebody goes and gets many tens of millions or hundreds of millions from patent infringement? That's actually better than most acquisitions. I think the average acquisition is like $35 million. 50?
I think it's 7.
70? Okay, 70. This can be higher. And this is after the company has failed to succeed commercially. If people were smart enough to maintain a good patent portfolio. But investors and entrepreneurs need to be aware of that there may be a different path to a successful exit at the end. So the last 5 years, there were each year 2,500 patent litigation suits in the US. 90% of them are settled before jury, up to 1 hour before jury selection. So you have to have enough, this is like a high stake poker, you have to have enough money to stay in the game because they are going to test you and test you and test you. They're going to double the pot. You have to be able to stay in the game. And then the last minute, 90% of the time, they cave. By the way, why is always the last minute? It's an interesting thing I have developed. Because those companies, of course, get outside patent litigation firms, so they pay them a lot of money. They pay more than it would cost us. So they pay maybe twice as much, $10 to $20 million. And as we know, very good top-tier lawyers love billable hours. So they're going to push, they're going to keep telling the company, oh, no, don't worry, it's under control, keep paying. We're going to go through the whole process, 2 years of expenses and this and that. But there is one thing that top lawyers dislike more than they like billable hours. What's that?
Going in front of a jury, not knowing what.
No, losing a jury. You were close. They don't like losing a jury decision because that's future business for them. Right? You lose a couple of those, you have no new business. So they will, the last minute, they'll change their singing to the clients. A few days before jury selection, say, well, you know what? Maybe we should settle here. But not earlier. Again, 80% of the patents are not good for a number of reasons. I mean, I can give another whole lecture, but many of them are prepared poorly. However, excellent patents, believe it or not, on an IPO roadshow, the CEO will be talking about the patent portfolio, among other things. In an acquisition, it's even more important. This is what the acquirer buys. They want to buy technology and product, but they don't want a competitor immediately to come after them. So they want to see that these assets are protected. And by the way, they go through incredible due diligence. I mean, it's just amazing. They know how to do that. And for companies who happen not to succeed commercially because of competition or other reasons, sometimes the patent portfolio is the last remaining significant asset. That's it. Thank you.
Three questions.
Yes.
Okay. So I was told to file in Texas. I don't know why.
To file for Texas what?
So there's a company that they're infringing on my patents, and so they want me to file in Texas. So I'm wondering if that is advantageous in your opinion, because I've never done this
So
before.
to file a patent infringement suit?
Yeah.
Yes. So, like everything else in the judicial system of this country, not all courts are equal. Talking about federal courts. And by the way, what is there? There's 360 district courts in this country. The vast majority of them cannot handle patents. They don't have the experience. So I don't know what percent will handle patents, but let's say a smaller percent. Then there is some district courts that they have, because a large district court, like in Texas, has a number of judges, district judges, and some of them would be 100% dedicated to patent infringement cases. So they are the top experts. Not only they know all about it, but all their court clerks, all their staff, I mean, they're geared how to deal with patent litigation. Some are more proficient than others, and some have developed judicial processes to go very fast, where others go very slow. Each court can have their own system how they deal with it. What are the steps, in what sequence, how much time each side has to respond to certain things. The Eastern District of Texas, the Western District of Texas, the Western District of Virginia are what they're called rocket dockets. They go very fast too. Talking about project management can make a huge difference on how things get developed. They have a project management system that is much more superb than anything else in the country. But there's other factors too. The jury pool. I remember somebody told me once that if you're going to sue Microsoft and your choices were Redmond, Washington, headquarters of Microsoft, or Northern District of California, you choose Redmond, Washington. Why? Because everybody in Silicon Valley, if they don't work for one of the large companies that they don't believe in patents, they have a cousin or a boyfriend. And Silicon Valley is, everything should be free. There should be no patents. I mean, people believe that software should be patentable, software should be free. And I hear that all the time, except that when I look who files the most software patents is IBM. Okay. So IBM. Yes. Historically.
But she got good advice to file in Texas.
Yes. Yeah. So the jury pool in those districts, especially in Texas, they tend to be leaning toward more a small entity. Consider them to be the underdog. Jury pools in Texas, they look down upon Silicon Valley lawyers. You say, is that part of the justice criteria? Well, I don't know. I guess it's life, but that's a good advice.
So my other question actually is continuing from that discussion is that if, when I win and this company is infringing on my patent and their business is actually using my technology, then do they go away or do they like buy licensing from me or and then?
It depends who the company is. Some companies, medium-sized companies may buy a license early on. Larger companies would go all the way to the end to test you that you have the money and the stamina to go through most of the litigation. And there's a few that for them is, let me use the term, jihad war. they will not yield, not only until they hear the jury ruling in your favor, but they're going to go and pursue every possible appeal. Because they're the ones who are the very, very die-hard that there should be no patents in this country. So they want to make examples. So it depends on the company. Yeah.
What do you think about PTAB?
PTAB? Let me come back, see if they have other questions, because it's a very technical question.
Any more questions?
PTAB stands for Patent Trial and Appeals Board. That's a very technical question. We'll come back if we have time.
Hey, Dimitri. Thank you for the presentation. So for us, like at StartUpNV, and when we try and look at patents, what do you recommend? Because obviously we're not as skilled and have as much expertise as you. What do you recommend are the few things that we look for in patents as a company without a lot of expertise, or that you recommend that we learn to be able to get a good overview of how defensible and how good the patent is?
Be friends with Demitri.
We can only use you so much, Dimitri.
Do you know how to fly an airplane?
Sorry?
Do you know how to fly an airplane?
No, I don't.
So if you ask me, what do I learn in the beginning so I start learning how to fly an airplane? How do I answer that? I do not know. I don't think. Sorry?
It's the most important thing in flying an airplane. Don't crash.
Yeah. Well, let me be practical.
If you are gonna crash, don't be in the plane.
First, people talk about having patents, but really what they have is patent applications. Patent application of the patent. Okay. Many of them never become a patent. Many of them change what it is being claimed during the process because they get rejected. So the first thing, the very obvious thing you got to ask is it a patent or a patent application? When they send you a document, you can tell, because a patent application will have 7 or 8 digit number, numerical, where,
They're both 8 digits now.
sorry,
They're both 8 digits now.
8, yeah, but it could be an older one,
Could be what?
an older one with 7,
Yeah,
right? Could be a 9.
well, in the applications.
Oh, no, but applications have different kind of numerology.
Mhm.
And you can see that it's not just a straight 7 or 8 digit numerical. Then you can ask, okay, so this is still application. Have you received any feedback from a patent examiner yet? And send me that correspondence. In the front page of that correspondence from the US patent examiner will say patents 1 to 29 are pending that you applied.
Claims.
Claims. Yes. Patents 1 to 10 rejected for this reason. Sorry, yeah.
Claims.
Claims. Thank you. Claims 1 to 10 rejected for this reason. Claims 11 to 22 rejected for this reason. Claims 23 to 29 rejected for that reason. Well, all claims were rejected. Now you say, what are you going to do about it? There's ways sometimes to overcome that, but you have to ask the question.
Okay, what's the alternative? If a bunch of claims were rejected, but a couple were not, what would it say?
It would tell you which ones were allowed.
Then call me.
Are they allowed, or are they like, is it definitive, or is it, it's not totally rejected, but you have to refine it?
That's complex answer. Well, let me see if I can try simply. Okay. How many of you know simple Boolean logic? Okay. So a claim has elements, claim elements. Example, I submit a patent a long time ago for a system that consists of, first, something that reads temperature. Second, something that actuates, activates a heating system or a cooling system. And third, a control system in between that ties the two. It's called the thermostat in your HVAC, right? That has three elements. Let's call them A, B, and C. Now, Jeff comes along and says, hey, okay, Dimitri has this claim, but I'm going to, if he claims, again, A, B, and C, he'll be rejected. So we'll find he'll be rejected. But he says, oh, no, I'm going to add something that is A, B, and C, but also it is used specifically for this kind of application. So he adds an element D. First question, is he entitled to a patent?
Depends.
Depends.
On what?
Less is more. So
No, the answer is he's entitled to a patent. But the tricky question is, does he infringe my patent? And the answer is definitely yes. Because if he's using A, B, and C, and I have A, B, and C, D allowed him to get a patent, but he's infringing my patent. What?
The value of that patent is less.
But they would issue a patent?
Yes,
And
think about it. Every technology today is evolution from a previous technology. So as we keep refining things, we can get a patent. Now, if that previous technology goes way back and is public domain, no problem, because then there's no infringement. So we go on. Jeff files a patent application that has A, B, and D. Is he entitled to a patent? Yes, he has something that I do not have. Is he infringing my patent? No, because he's not practicing C. Okay, but what if this D or E or Z element becomes trivial at the end of the day? What if the examiner, by bringing up prior art, forces you, in order to get a patent number, that's what most patent attorneys will do, unfortunately, to keep adding elements. Eventually, you can add enough elements to get a patent number. But the value of that patent is zero because it's infringing previous patents. So back to your question, Maggie, it depends. How can you refine it? If you refine it by adding elements, no value.
So they don't make any judgments like that.
Who?
The patent officials are not going to say you're close, but no cigar. You have to.
No, they look very, very technically on the claim elements.
Okay, so I would also like to understand, different subject, but something that affects all of us is like, what is the timing on these things? If somebody applies for a patent and maybe they get a provisional patent, then how long?
There is no provisional patent.
Then why do people keep saying they have provisional patents?
Okay. Only in the US, you can file what's called a provisional application.
Oh, so there's only provisional applications.
Application, not patent. And then in the provisional application, you have to have the whole description. You can almost not change it later, but you don't have to have any claims. And you do that as a matter of expediency to file the provisional application quickly because that sets now your date. But within a year, you have to convert the provisional application to a non-provisional application. Now that's the full application, including claims.
And that is incumbent on the person who's filing for.
Yeah.
Okay, it doesn't happen automatically.
No,
So if they don't do it, it's just nothing.
if you don't do it, the provisional application disappears,
Okay.
never shows up anywhere. If you get the conversion to a non-provisional, it becomes part of the record.
Okay.
Yes. Sorry?
How many convert, generally speaking? What's the percentage?
Oh, well, look. Why would somebody, let me first change your question a bit. Why people would file provisional patents? It's for two primary reasons. Because you have the 1 year, it costs more than to go through the lawyers and get a non-provisional, just cash flow. So people say, you know, I'm going to delay it for 6, 8, 9 months for cash flow purposes. Others, they say, I really, really care about the so-called priority date. So I'm going to first file, I prepared my whole specification, I prepared everything. Now I want to have the lawyer work on the claims. It's going to take another month, month and a half. So I'm going to file this as a provisional, but I will continue the work. So 2 months later, I file the non-provisional. I would say, I do not know the percent, but I would say most of the applications of small companies go through one or the other. I mean, it would make no sense not to do the latter, because to file the non-provisional will cost you like $300. So why not capture that date rather than a date 2 months later or whatever? For $300 is that time difference may be worth. But
So
no,
we hear provisional patent. We have a provisional patent. We hear that as an investor. So when we hear provisional patent as an investor, how should we be thinking about this? Is
be
simply,
very
they've just
skeptical.
simply applied.
Be very
basically.
skeptical, because most provisional patents, I have seen where engineers will take a technical document, like a specification, and file that as a provisional patent. It's worth nothing. So unless somebody who knows about patents has prepared the provisional patent, and they know how they're going to go to the non-provisional specifically, it may have no value.
Perfect. Thank you.
Yes, so yeah.
To win it.
6 years from
The
the date
time
you
the
filed
date
the
I filed,
provisional.
yeah.
So it took you 5 years to get the non-provisional.
And I had a call with the examiner after the third rejection. It's like a last Hail Mary call. And you have to kind of plead why your patent is special and novel, and you have to explain it. And she took my claims and then she translated what I said, and then she helped create the wording for my patent acceptance.
The examiner?
Yes.
You're very,
Really?
very fortunate.
Yes.
They don't, they almost never do that.
So you had to file an RCE to get to that third one?
A lot of time and money.
Cheyenne, what?
So you mentioned that you don't recommend patents for companies that are hardware, software systems. But then it was also the fact that the second highest thing that was patented last year was AI. So how does a third highest?
Third or fourth.
So how does a company that is software go about protecting their IP? We saw a successful version of this in Sierra Angels last year, Grid Matrix, that you had seen that, and I think you were optimistic about that, what they had. So how does a software company go about protecting their IP?
How do you do that? So,
Yeah,
by the way,
Demitris as your friend.
Chad is kind of unique here in this audience because number of circumstances that connects back to Sierra Angels. He has a new company, software, and he has come to me and my team to help him figure out even what's patentable in his software. So, very experienced. What has been your experience?
That's been awesome. But it's very hard. Like it's from what I perceive, what we have to how they document it. I wouldn't know which way to hold this. Is very different. So I'm not allowed to use that word you said. I'm not allowed to use, right? Can I use the word?
Go ahead.
What was it? Trivial or obvious? I'm not allowed to say that.
Yeah.
No, they see value you don't perceive because you're too deep in the project and too involved. And you need a third party view because the net result of what the patents or the provisionals end up being are often ring fenced around the core concepts of what he spoke about, which is actually quite important. You focus just on one particular idea because that's all you see. They see the whole ecosystem. And fortunately,
I have a team. We help companies. By the way, we're not lawyers. We're not patent lawyers, but we understand the value of patents better than any patent lawyer. And we work with patent litigators to sue big companies. So we understand both sides.
yeah, I mean, like to take 2 steps back, a very obvious example is I've been involved in 2 patents before, and they're literally worth nothing, just because they were done, as Demitris said, just drag and keep going through revisions to try and end up just getting a patent.
So your claims got so narrow.
By the way,
Their focus is to minimize. That's why when you went the Boolean thing, I said the inverse, but I knew it because you're looking at protecting the patent.
I met Chad recently, a few months ago. He's been very successful in his career. Very, very good software engineer. But I think he would agree that when we started the discussion, we asked him what it is that is unique for you to patent. I don't think he had any idea. Now, by the way, this is what happens when you work for a company. Your CTO or CEO says, you have good ideas. Let me hook you up with this very good patent attorney and get some patents. And go and apply for some patents. What is the first thing that the patent attorney would ask, or the company? That the inventor puts together what's called the invention disclosure statement. Write down what you think that you have invented. Let me tell you, that's where the process goes wrong to begin with. Because in all kinds of patents, but especially in software, engineers do not know what's patentable. So when you put that down in the paper and the attorney takes that and starts writing something up, this is garbage in, garbage out. One second. We never asked you to write anything down.
It's more material.
It was a discussion. It was like, tell us, no, Chad, this is not that way. Let's go somewhere else. And we keep interrogating. And from that interrogation, we extract what we think is patentable.
Yes, so if I take one step back, we presented the concept to the sales partner of ours. And he says, guys, you've got to protect that. And what we ended up protecting is that's like 1/4 of the tech we did, just to give you an idea. But yeah, it's we ended up not where.
Yes.
Pending.
We applied. We
It's
applied.
provisional. It's that provisional thing.
Not looking at prior art.
No, we do.
Provisional.
Oh, you.
We got
Oh,
the
yeah.
date.
That's the only way you get it determined.
We do very thorough
Not the
prior.
claims. Yeah,
Huh?
That's the
claims.
difference.
With claims?
Yeah.
So it's going through examination?
Not yet. It's just.
We just apply them. They need to have a beta test. So we need to file the patents, the applications before they can go to beta test.
Okay, so we're going to start the wrap up. I know Madeline heard Cheyenne's question.
Okay,
and,
look,
and then
Mary
Mary,
first.
we'll go Mary and then Madeline.
Yes.
And then I have one. And then if there's any burning questions, we'll get them because we're 7 p.m. now.
So my question was then, shouldn't people be able to rely on their patent attorneys to assess the value and the quality of their patents?
Who said that? Good. Okay, so if you have a patent attorney,
Say yes.
They can't believe.
guess what?
I can say yes. No, but I
We can say yes to
Yeah, but yes,
Go
but-
ahead.
say.
Oh, no, we're not patent attorneys.
Yeah. Patent advisors.
We're not, no.
Yeah.
Okay. So as your patent attorney in law school or wherever, even if you went and had some specific training in patent law, how many courses they took in the value of patents or economics of patents or anything like that? Exactly. None. Zero. My firm, we are tightly affiliated with 8 patent law firms around the world, from China to Israel, everything in between. We pick them, and they do the back end for us. They do the claims. So we work front end, back end.
So you do PCT stuff too.
Sometimes customers want us to file in Brazil. I don't know why, but different story. So those top attorneys that we select through years of experience, they have no idea about the value of the patent. They tell us that. Just guide us. Tell us where the value is, so we'll help you develop better claims. That's our job. So now, you know what a patent litigator is? Patent litigator is a lawyer who goes to court for patent infringement. What's the overlap in capabilities or even vocabulary between a patent attorney who develops patents, who are basically engineers?
Prosecutor versus litigator.
Right.
So the prosecutor helps you get the patent, the litigator helps you keep it.
Or fight it. Yeah, but what's the overlap between their skills? None. Even the vocabulary is different. The patent attorneys are engineers. They have to understand the technical aspects of it. The patent litigators are performers in front of the judge and the jury. And I'm not saying that in a negative way. I'm saying they know how to do that. So yeah, it's different. But patent litigators do know the value of patents. So somebody asked me before, when we try to find a litigation investor and a law firm to undertake the case, they're going to look, what is the asset? Is it worth for them fighting? Absolutely. But it's different than patent attorneys.
All right.
Was that
so-
your whole question?
All right. So Madeline online had a follow-up question to Cheyenne's, and then I've got one final question. I'm going to try to wrap this up. Madeline, unmute yourself and ask your question.
Can you all hear me?
Yes.
Okay, great. If you are a software company or you don't have a physical good, you have an advanced algorithm or code or something like that, how do you decide when and what to patent versus keeping things as trade secrets? And how do you evaluate that as an investor?
Okay. I discussed earlier, Madeline, that I do not believe in trade secrets in high tech. The moment you issue your product, I can reverse engineer it no matter what it is, and I'll know exactly what you used. I will use it freely, and you have no protection. And you cannot come after me with a trade secret.
It's, for lack of a better term, in the public domain.
If you can patent
people to build on it.
software technology, you should patent the software technology. Not all software technologies are patentable. Let me say that. The patent law stipulates that anything that is part of nature cannot be patented. So equations and algorithms per se, because they describe nature, math describes nature, cannot be patented. Applications, pure applications, cannot be patented. It has to be something deeper that is going on, like something that's going on in the background of the application. That is what you can possibly patent. So, as I said, I don't believe, Madeline, in trade secrets, and anything that can be patented in software, you should. And now, what's patentable or not takes a little bit longer, but if you have something, talk to me, I'll guide you through.
Excellent. All right. So I want to finish with one question that's sort of related, I think, to what you just said about things in nature, et cetera. You and I have talked about something called the Alice principle.
Yes, that ties to that.
Okay. So I'd love to just hear about that one as sort of the final step here.
And I'll
then-
talk about PTAB separately if you want.
Yeah.
So, about 10, 11 years ago, the Supreme Court of the United States had to look at a patent case. It was Alice Corporation versus some three-letter acronym company. But that decision now is always referred as the Alice decision. And what that decision clarified is that anything that humans can do is not patentable. So, give you an example. You drive your car and you put me in the back seat and I observe how you drive, how fast you accelerate. You developed a technology, something that you put in your car and monitors how you drive. how you accelerate, decelerate, how quickly you take turns, your whole behavior, and determines a baseline. And then someday detects that you are driving differently. You're tired, you're under influence, you're under stress and you're rushing. So you're driving now differently and presumably more dangerously. It warns you, hey, you're doing something wrong here, slow down. My car warns me when I drive for too long with no rest. Or if it gets to be too extreme, shuts off the engine. Is that a good invention? Of course. I should be using one. But the Alice doctrine says, okay, you can put a person in the back seat and you can do exactly the same observation and warn the driver or force him to shut off. Therefore, that invention of that machine that does that is not patentable because a human can do it.
And I do it right.
From the passenger seat.
All of the spouses out there.
So yeah, the Alice thing is something that one needs to consider when it comes to something being actually discussing a number of things with Chad, his technology. Some of the things were Alice. They said, no, don't go that way. Let's go back to the deeper science and capture those.
Okay.
Any other question, Madeline? No?
I want to thank Dimitri for the
My pleasure.
90+ minutes that he's now spent with us. So, yes.
Thank you.
I think we could go on for another 4 hours, but I'm going to cut us off. And if there's things that we want to talk about afterwards, great. Thank you so much, sir, for doing that.
My pleasure. By the way, anyone here, if you have any question about patents, I'll be glad to spend 15, 20 minutes with you addressing it. Part of your ticket price here.
Right. And if for whatever reason you escaped from this room tonight, you don't have that conversation and you can't remember Dimitri's name and how long it is, you all know me, so, or Maggie, and we can get you in touch. And before we leave, I don't see Brian here, but I want to thank our sponsor who's hosted us here at Woven Workspaces. So for a lot of us in Las Vegas, this is new. I mean, this place has been open maybe a month and a half. We've done a workspace here, and this is our first masterclass here. So thank you, Brian, for hosting us. So if you do have events or you're thinking about a co-working space for yourself, please check out Brian and Woven for your various demands. So again, I want to thank you. Ah, okay. I didn't even know that. You get a 20, if you mentioned this particular facility or you came to a StartUpNV event here, you'll get a 25% discount. So thank you, even though Brian's not here, thank you, Brian and Woven Workspaces for putting us up. What a, just cool is what I think of it. It's just high class and cool. And I feel like since I was a teenager in the 70s, it just sort of brings it all back for me. I just need some angel flights and some high-heeled shoes. So I know the younger people are going, what? But watch Saturday Night Fever. Thank you, everybody, for coming out tonight. Especially thank you to Dimitri and thank you to Brian and Woven Workspaces. And we will see you at our next event. 1 p.m. City Hall in the City Council chambers. We will have 7 companies pitching. We promise at least one company will get at least $200,000. I suspect that at least one company will get more than that, but that's our promise and we will definitely keep that promise or something better. So please come out. It'll be a great day of pitching and celebrating and it'll be a fun day. The weather should be lovely as well. So come on out and see us tomorrow. Anything else? Anything else that I forgot? Madeline or Maggie to announce?
Another founder.
Yes, so yeah, just watch for us online. It'll be announced as everything is. So hopefully we'll see some of you guys out tomorrow at Angel NV Well, I know that we'll see some of you out at Angel NV, and hopefully everybody will see it. We'll see you at Angel V. So thanks again for coming out tonight, and I'm going to stop talking now and say good night.